marks on this 3-year-old child, hitting this 3-year-old with a belt. And I talked to Dennis, and Dennis said, no, he's a really good guy, like, you're gonna like him when you meet him. And I really didn't believe Dennis. And then I met him, and Dennis was right, and he testified really well. And he took all of Dennis's advice that Dennis had given at the detention hearing. He got those books. He was on the wait list for a parenting class, I think, couldn't get in. He got the books, testified to what he learned about. The county said it was actually Medvine. She said it was ridiculous that, oh, he thinks he read this book and now he knows. But then...
Well, and Marpet sustained, obviously, the A and the B, probably, because that's his way. And detained, and found that dad, posed a risk and could not return to the family home. And so Candace filed the notice of appeal, and the appeal happened. And now let me just back up. So in our client's hero's journey, there is, like anywhere else, there is a villain, and I call him the damn villain, D-A-M. The villain for all of our clients, D-A-M, denial, anger, and minimization. Those are the villains. In so many, in case after case, in AE, in JN, in JK, in BT, and Briseño C, in case after case after case, where our clients are either they are found that the allegation is not jurisdictional, or yes, something's jurisdictional, but they don't pose a risk to their children and should be allowed to have custody of their children. In case after case after case, the appellate court comments on how the parent is not in denial. The parent is cooperative with the department. The parent is not minimizing what happens. And so denial, anger, and minimization are the three villains. And it's at the detention hearing where you try to help your client slay those villains. And then what we want to prove, and again, I'm a USC graduate, so I really hate that this acronym comes out this way, but it's AUCLA, ACLA, and I have it actually written on the top of the copy of Briseño C in here. Acknowledge, understand, commit, learn, and apply. Again, every single one of these cases uses the word acknowledge. When they're finding that something's not jurisdictional, or they're returning the child to the parent, that the parent acknowledged that what happened was wrong, whether it was something they did or something someone else did. They acknowledge that it was wrong. They acknowledge the truth of the situation. They may not acknowledge every detail of it. They don't have to. They may not understand it completely. They don't have to. But the appellate court repeatedly comments and is clearly looking in the record for the parent acknowledging the problem and then understanding the problem. So our client in AE, the father in AE, he acknowledged that yes, he shouldn't have hit his 3-year-old with a belt, certainly not hard enough to leave marks. And he was on the road to understanding why he did that. He had gone into his own childhood, he realized that's the way he was raised, so he did it. He also talked about how being such a young father, the only way he knew how to parent was to, be really strict by keeping this 18-year-old and this 20-year-old, had an immaculate home. And that was because that's the way they were surviving. At such a young age, to make it work, everything had to go by the book. And father saw this. Father had made that connection. He understood that, yes, he was raised that way. He thought that's what he should do. He thought that she was just being openly defiant, and that if he didn't punish her now, she'd be pregnant at 16. This is where his head was going. Commit. Again, these are words that are used in time after time after time in these appellate opinions, and that's why I urge you to read these appellate opinions. Commit. The parent had committed to changing. They had committed to classes. They had committed to therapy. Commitment to resolving the problem, to making sure the problem never occurs again, is one of the big things that they talk about in the appeals. And learn. The father has learned. And the father had learned, frankly, at the detention hearing, he had probably learned enough to carry the day with the appellate court, but the fact that Candace put him on the stand, that she didn't worry about, whether this 18-year-old guy was gonna, actually by this time I guess he was 20, but, whether he was gonna screw up or whether he was gonna, be a loose cannon. She didn't worry about that. Her client had a story to tell. She knew the story, he knew the story, she asked the right questions, he gave the right answers, and it didn't matter. I mean, it mattered for him going home that Marpet, didn't buy the argument and just followed whatever Linda Medvine told him to do. But he probably won't do that again. And about 2 weeks ago, we had a case. Now again, case law is not something you cite at a detention hearing. What you do is you use the case, you remember the facts of that case, and you try to shape your case to look like that case. In other words, plagiarize. You're going to tell a story that's completely plagiarized. You can plagiarize from AE, you plagiarize from JN, but you need to read those cases. You need to be able to actually understand what those facts were. One of the most abused cases, I think, is Daisy H. And I think a lot of us know Daisy H. and use it for the proposition that a remote act of domestic violence or a single act of domestic violence is not sufficient to take jurisdiction. That's not at all what happened in Daisy H. Daisy H really belongs in the category of family law cases, and I'm not going to tell you anymore because I want you to read it. Well, I'll tell you one more thing. It was one of those cases that came in the detention hearing. The thing that the attorney probably noted at the detention hearing was that they had come out of family court 2 weeks ago. They had been in family court 2 weeks ago, and guess whether it was the alleged perpetrator or the complaining party who had gotten the short end of the stick in family law court. So again, take that story, run with that story, and by all means use Daisy H. in telling that story. But please don't have a case where dad has, broken the mom's nose and given her a black eye, and this is the third time it's happened, and you're trying to make it look like Daisy H., through your framing. No, there is no framing that's ever going to make that case look like Daisy H. That's not what Daisy H. does. Anyway, I want you to read it, though. Read it, because we get these ideas in our head of what these cases stand for, and we forget what the facts were. And if we don't know the facts, then we can't plagiarize those facts and try to shape our current detention into being that case, into having the successful result that those cases have. And again, that's what the storytelling is all about. Let me see. Oh, okay. Along those lines of things not to argue at detention, don't argue nexus, don't argue case law, don't argue jurisdiction. I pulled the bench, and by a very large margin, the thing that they repeatedly said is, don't come to the detention hearing and tell me the report is a pack of lies. I can't do anything for you that day on that issue. That's your issue at trial. Come to me at the detention hearing and tell me that the department did not make reasonable efforts to avoid detention. Come to me at detention and show me what safety plan could be put into place to make the child safe in this home so that I don't need to detain the children. I do not want to detain these children. I am detaining them, even 404. I am detaining them because I feel there's a risk. So please, the reasonable efforts argument is the argument they're waiting to hear. And when they can, they will jump on it. When you can go to, and I see Bob Stevenson shaking his head, nodding, and he's a former bench officer. He's telling you, he's agreeing with you. So, when you've got, here are some signs to look for. You've got, 6 relatives there. Really? 6 relatives, you know, and the department couldn't find one person who could move into the family home to be an extra set of eyes on the family and allow the family to stay together. You know, they've also got the other tools that are at the department's disposal for a beefed up safety plan or unannounced home visits. You know, they can make those unannounced home visits 3 times a week. There are people that the department employs who just go around making unannounced home visits. They can also call in ER workers from other departments. Of course, that can backfire on them because, you know, we had a case where they called in an ER worker out of another spa, and the ER worker went out to the home and didn't find anything wrong at all. And then the supervisor of the original spa called the ER worker and tried to get him to change his opinion. That was a fun trial. So please argue reasonable efforts. Please argue a beefed up safety plan. Please be out there in the lobby working with mother's counsel or father's counsel, working with the other parent's attorney, working with minors counsel, trying to come up with a beefed up safety plan. Some of you have minors counsel in your courtroom who will help you. Some have minors counsel in your courtroom who won't help you. But triage these things. You know, you're probably not going to get the department on your side, but that doesn't mean to ignore them. Let them know. You never know. You know, people as tough and as balls to the wall as Valerie Steele will surprise you and say, yeah, if you could do that, I agree with you. You know, sure. You know, I'll call that out and see if we can get the department even to agree with that. You want to tell your client what things are going to look like when they come back. You want them not to be surprised by what a trial is. You want them not to be surprised. Well, first of all, you want to tell them what it's going to look like when they go in there for the detention hearing. You want to make sure they know that the judge is going to talk about a lot of ultimate consequences, that you are very, very hopeful that none of those ultimate consequences, like adoption or termination of their parental rights, are ever going to have to apply to them, but it is the judge's job to inform them. You let them know that it's really good, you only get one chance to make a first impression, that this is going to be their first impression on the judge, that it's really good if they can be listening, if they can be attentive, if they can avoid crying, that there will be Kleenex and crying time available after the hearing, but if they can just get through the hearing, paying attention to the judge, putting the judge's needs first. And can anybody tell me what is the reason why judges get upset when your client cries at the detention hearing?
Impact on the kids.
Exactly. It's because the kids are sitting right there, and the kids are getting upset, and the parent is being selfish. The parent is again putting their needs ahead of their child's, which in some way is why they're there in the first place. So you need to encourage your client to make a good impression. Do not hesitate to tell your clients to cover things up. You can, if you feel comfortable talking about appropriate foundational garments, whatever you feel comfortable doing, but it is your job to make sure that your client makes a good impression. I always tell my client, do not sit like this in front of the judge. That is bad body language. It creates a wall between you and the judge. The judge doesn't want to have any walls between you. The judge wants to like you. I want the judge to like you. So nod when the judge asks you questions. Yes, Your Honor. And by the way, I only learned this a couple of years ago. You know, it's not polite to say yes, sir, or yes, ma'am. It's yes, Your Honor, just in case anybody didn't know that, because I did. So make sure that you take responsibility for every aspect of your client's presentation. And don't be afraid to say, if you think your client is bubbling under, don't be afraid to say to your client, may I have a moment? And then when the judge gives you your moment, take your client outside of the courtroom. She's giving you a minute. She'll say, yes, sure, take a minute. And then just take your client outside of the courtroom so they don't blow up in front of the bench officer. Remember, you're in charge of that. You are the director of this little play that is happening at the detention hearing. You know, everybody else, if they thought about it, would want to be the director. But if you're the only one thinking about it, if you're the only one acting like a director, then you will be in charge. You know, if there are things about the dynamics of where you sit at counsel table. You know, it dictates what order you will be called on. It also dictates what you can see. the person who's standing at the far end because there's not enough space to be seated, that person actually has a unique advantage because they can see the expressions on everybody's face at county council, and they can see the judge. They're the only person who can really see what the judge sees. And oftentimes that little perspective alone will allow you to know what's really happening in a way that none of your colleagues will. Okay, we only have 15 more minutes, so I will stop there and take any questions. Does anybody have any questions? If not, we can talk about a couple of other things.
I have a
Right?
comment.
Yes.
I just want to take this opportunity, since we are talking about first contact. I've been writing to cancel all social media accounts on our NCR form almost once a week. Either one of my clients or a colleague's clients get themselves into trouble on Facebook. I've had clients get into trouble merely for liking an inappropriate photo, much less what I saw yesterday with one of Jennifer's clients, which was a very disturbing video that she posted publicly. So I have that conversation with them at the very first contact. I put it in writing on the form that they sign.
I mean, yes, you deserve a card. That is such good advice. Yes, I've seen so much damage. I've seen allegations proven with a Facebook picture. Not once or twice, but repeatedly. So yeah, you guys, we need to be on that. We need to be on that. Anything else? Yes?
I just had a couple of questions.
Sure.
The first is, I think, you gave some examples and recommendations of working with your client at detention hearing. One of the things I struggle with the most is time. And I think it's great to be able to do all those things, but I just don't know if you can comment or give suggestions, because many times I just feel like I'm very pressed for time, and I don't like that. I don't want the client to feel that way, but it's reality.
Yes.
And then
Let me answer that one first. That's a great question, and the answer is actually rule number 2. So does any further know what rule number 2 is?
It shouldn't be just
Be lazy.
Mr. Mellis. It is be lazy. Be lazy. You need to be jealous of your time. I'm not saying be really lazy. None of us are capable of that. We work for Ladle. But try to be lazy. Try to figure out shortcuts. And do not waste your time on the losers every day. One of the secrets that I know as a supervisor is that every single one of you spends more time on your losing clients, beating your head against a wall, trying to come up with a defense where there is none, and time and again, I'm telling my attorneys at least, stop it. Go on to a client who needs you. There is a client who is waiting for you to put together a full-throated defense with a subpoenaed therapist, a subpoenaed policeman, some subpoenaed police reports or medical records. And by the way, as far as discovery goes, that's there's a lot that I'm not able to talk about right now because we just only have an hour. But discovery is another important thing for you to think about. But yes, if you stop wasting time on the cases that you cannot win, trying to think there's something wrong with you, that you should be able to come up with a defense, just handle those cases. Go in there, repeat your client's argument that's crazy. And move on to the client that needs you. I think that's my number one piece of advice to help you with your time issue.
Then my second question, and it kind of relates, is sometimes, especially at detention, when I'm talking to a client, and other times they can be somewhat combative, argumentative, and I feel like I spend my time trying to get them to calm down, trying to get them to try and listen to anything I'm saying, but I often lose that, and they're just upset, which I understand that, but I spend all this time with that. So do you have any advice?
Ms. Firth.
That's probably one of the most common questions that so many of the attorneys, we chat about it all the time. And my advice is always we don't power struggle with our clients.
Right.
Because many of our folks, it's behavioral, it could be mental health. I don't know what the issue is, but to power struggle with our clients, it just doesn't work. Because what I see is our attorneys are in this really great, rational, legal mind explaining exactly what has to be done, and the client can't absorb it. So you know what? It's the client. So all we can do at a certain point is advise, document our files, what we're advising our client to do, and then let it be. If the client wants to take the stand and say there is a global conspiracy, then you know what? That's the client's right. Let them take the stand. And we have documented the file. And sometimes what I do is I will write my advice to the client, and I'll even tell the client if what you want to do works, because I'm not God, and I've had crazy ass clients take the stand, and damn if it doesn't work, then I really feel like who's really crazy here. But I will sometimes, and it's worked sometimes, most of the time it doesn't. So I'll just write on the activity sheet everything I've advised the client to, and I say, look, if you want to do this, as long as it's ethical, like they're not going to lie and put false evidence in, I say, I want you to sign it. Because I don't think this is going to work, and I don't want you to be pissed at me when it doesn't. But I'm not going to fight with you. This is your life. These are your children. I think the way you want to do this is wrong. But to power struggle with a client is it's a constant setup, back and forth, back and forth.
A couple of techniques that I use sometimes to avoid that power struggle. That have worked in the past. One is I tell all my clients, especially when it's anger management issues, something like that, I tell them, listen, the department can say anything it wants about people, but what happens is the real people in their flesh and blood walk into this courthouse and they go before the judge and they prove who they are. And don't make no mistake about it, the impression that you're making started when you walk into the courthouse. There are people talking about you the entire day while you're here. Other people who aren't even on your case are commenting about you. The bailiff is commenting about you to the judge. We're not in control of who says what here. We're only in control of our own behaviors. So you're going to walk in here and you're either going to prove that you are an angry guy who's out of control, or you are going to prove that you're not that guy, that you'd have no idea who the social worker's talking about. Sometimes they'll see that because, especially the closer they are on the spectrum from anger management, the closer they are to domestic violence, that means the better they are at manipulation, and they will usually buy into any argument you make that allows them to be manipulating people. So, again, if you remember my mental health training a couple of years ago, part of that was talking about entering into your client's world. If they were, my favorite client was the one who believed that her child was a superhero and therefore needed to be raised by superheroes if he was going to come into full possession of all of his powers. And I was like, oh my God, please. I am so there with you. That is absolutely true. Yes, I believe there's a superhero inside of all of us, but they're quashed before they graduate from high school. I'm with you. And, and she loved me. But it wasn't manipulation. That was true. So you can also tell your angry clients, listen, we will go get angry. I also tell them you can call me anytime you want and reach my cell phone, leave me a message, and so I give them all my cell phone number. You can talk for however long it'll talk. You cuss me out, you tell me about that motherfucking social worker, all you want. And that is your safe place. I'm your lawyer. I am forbidden by law from ever saying a bad word about you. So you take advantage of that. You take it all out on me. But when you're with the social worker, it's yes sir, no sir, yes ma'am, no ma'am, and you want me to jump, how high? And some of them will buy that. Sometimes that works. But reminding them, and I'll even do this with your clients, just probably giving secrets away, but I'll be walking by someone who's making a fool of themselves, and I'll just, I don't care if they're my client or not, I'll say, the walls have ears. And usually they go, thank you for telling me that. Or the grandma says, thank you for telling him that. Doesn't hurt. We all represent parents here. It doesn't help us, when someone, who's been so hurt and so traumatized by the situation and is acting a fool, it takes a village. Maybe it takes a village of attorneys to raise a parent. So, let them know. You're welcome to talk to any of my clients if it's just to say the walls have ears. Just another couple of things, because we have some more gift cards to give away. So does anybody know the case that basically says 300C means exactly what it says? Yes. You actually had it in the packet. Okay, what is, let me start talking and shout out the name of the case as soon as you can. And this is the famous case where the parents at the detention hearing were both in jail. Yeah. Okay, who was that? That was you, and that was you. All right. Yes, it's JN. We use that a lot. We cite it a lot. We try to frame our cases into it a lot. But really go back and read it, because it's real interesting to see what happened at the detention hearing. Both of those parents were in jail, and some, just awesome lawyer. Was that Orange County?
No, it was Vivek Tandon.
Oh, right, it was Vivek.
It was Vivek who used to be in our law firm. He left. He went up to San Jose. Everything that you are now learning now, he took to San Jose.
And he structured that case. He told them, do not try to talk your way out of this. What you did was horrible. He did acknowledge. He made them understand. He made them commit to never doing this again, to getting better. They went to their therapy. They went to their AA meetings. And he made them learn, and he made them apply what they learned. So, it's a classic case, but read between the lines. All these cases, when you read all these cases, really read them carefully. Pay attention to the dates also. Take a look. I don't know if it's a chance or not, but it's real interesting how these cases that seem to go well have a jurisdictional hearing following pretty quickly after the detention hearing. I don't know very many cases that have a juris hearing 6 months or 8 months after a detention hearing that go well. I think that these cases overall, time is not on our side. When do you set a no-time waiver trial is a question that nobody's asked, but so I'll answer it anyway. I set a no-time waiver trial under the following circumstances. When I'm so mad that I didn't get release at detention. Whenever you're feeling that, whenever you feel like it should have been released at detention, you have to set a no-time waiver trial, because you're probably right and you will get that kid home at the dispo. So why would you wait 2 months to get to dispo when you can get there in 3 weeks? That's heartless. I mean, there is a parent out there who does not have their child. So when we don't set a no-time waiver trial, we are adding 4 or 5 weeks to the time that child is away. Time for a child to get fed up in a foster home and run away and get pregnant. I mean, God only knows what can happen. But, just set the damn no-time waiver trial. You can always un-no-time waive it. You can always waive it. Right. You can always waive the time later on. But again, when do I not set a no-time waiver? When I am writing down the defense on the activity sheet, and what I'm writing down is, need the police report, need to subpoena the police report, need to subpoena the cop. I need mom to have 4 clean drug tests. Those are the kinds of situations where and I explain to the client, I could get you trial in 3 weeks, but I think we need this, this, and this in place before trial, so it's going to be more like 2 months. You in agreement with that? And usually they're going to take your advice. That's what you're there for. Also, on your activity sheet, I did write down what to write down, what not to write down. My client's crazy. Client's an asshole. Don't write that down, because there's lots of good stuff on that activity sheet that shows what a good job you did and how much you thought about that case. And if you wrote my client's an asshole, you're going to have to pull it out if you ever get substituted out. you're not going to be able to, and no one will see all the good work you did.
What about client appears to be under the influence?
Pardon me?
Client appears to be under the influence, same thing on things like that?
You got to decide how bad it is and whether they can get through the hearing or not. And, there's a time to send them home. And there's a time to realize that, well, wait a minute. We're not going to be denying that my client has a drug problem. That's not the defense. So if that's not the defense, let the court see my client totally, high, and come back in 3 weeks with 3 clean drug tests and her hair done and her makeup did and
I
her.
meant like documentation on that.
You never need to shy away from writing the facts. So actually, if you're tempted to write "father was an asshole," what you would write instead is, I